Calling our next case, Elsayed versus F&E Oil. Good morning, counsel. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free fire zone, and you may reserve time for rebuttal if you can.
Thank you, Your Honors. And I'm going to try to reserve a couple minutes for rebuttal. May it please the Court, Tali Wendrow on behalf of Plaintiff Appellant. To this Court's question whether Lugo is consistent with Michigan's comparative negligence framework, the answer is simply no. Lugo moved the open and obvious defense from the breach analysis to the duty analysis and has had the effect of resurrecting contributory negligence. We respectfully request that this Court overrule Lugo and Hoffner and replace it with the third restatement's approach for analyzing premises liability cases to invitees. Justice Levin's dissent in Riddle was prescient, where he clarified that the issue before the Court was addressing was not a question of duty, but rather a question of standard of care. This distinction has been lost or ignored in subsequent cases, and then Lugo, poorly paraphrasing Bertrand, simply announced the special aspects test. The second restatement on which Lugo purports to be based imposes obligations on property owners through sections 343 and 343A. However, through its special aspects test, Lugo has eliminated the obligations of the property owners and has focused only on the invitees. As a result, the question of standard of care, whether a defendant has taken reasonable measures under the conditions that exist, has been framed instead from the defensive standpoint as to whether the plaintiff acted reasonably. This is why Lugo is inconsistent with comparative negligence. It has effectively resurrected the abolished doctrine of contributory negligence. The case at bar highlights this, where the Court of Appeals literally ignored the fact that the defendant took no measures to diminish the hazard. Instead, the Court focused entirely on what our plaintiff could or should have done differently. There was no evidence that she acted irresponsibly, that she wasn't wearing high heels, nothing like that. Adopting the third restatement with its clear pronouncement of what duty exists will assure that courts apply the proper duty, followed by standard of care analysis, in premises liability cases in the future. And to the question of why, to the issue of why the third restatement might be beneficial or helpful, we are not advocating for the complete dismantling of the status-based duty analysis. And Section 51 clearly articulates, let me back up, the issue with the restatement and why reaffirming the restatement second is problematic is because its language is ambiguous, it's confusing. The second restatement, 343 and 343A do not speak to duty. They use language which made sense in context of a contributory negligence world, where they refer to is liable, is not liable, and courts subsequently, and practitioners, have confused the term liable with duty. They're separate issues. Liability is the culmination, of course, of duty, breach, proximate cause, and damages. You can have a situation where there was a breach of duty and there was proximate cause and there's no damages, and that gets kicked on summary disposition. Liability needs to be a separate concept. So what
Can
the
you
second
help me,
yes.
talking about the restatement, the third. Obviously, as you've indicated, there's a big distinction between the second and the third as to the status of the plaintiff on the land, right?
Correct.
Here in your case, we have an invitee, so that's not really that relevant of a distinction between the second and the third.
Correct.
But another, what I view as a big change from the second to the third is this issue of unreasonable risk of harm, right? And the third restatement says, Section 343 of the second required that the condition pose an unreasonable risk of harm to the entrant before a duty will arise. And that requirement is not employed in this restatement, because whether a risk is unreasonable can only be determined in light of the burden required to eliminate it. Reasonable care, in other words, must be exercised with regard to all risks. Why in Michigan, I mean, are you advocating that the third restatement in total be adopted? Or is there some utility to an unreasonable risk of harm remaining part of the standard? And here's my example that I want to give you. Like, look at the first stairwell. You know, in Bertrand, you had two staircases, right? You had the one that, you know, a staircase presents a risk of harm in general, right? Like, you can fall down a staircase or a step even. But the utility of a staircase to transition from one level to another is apparent. It's necessary. You know, maybe you can't make it safer. So it may be a risk of harm, but not an unreasonable risk of harm. And I think that fairly read Bertrand probably says that about the first staircase. There may be conditions and circumstances surrounding the staircase that make it unreasonable, such as perhaps the second staircase in Bertrand. Or a curb on the road. It presents a risk of harm. You can fall off a curb, but there's a utility to it. There's a, you know, it's a common occurrence, it's necessary. Why doesn't that make sort of eminent sense to remain in our jurisprudence that the condition has to be an unreasonable risk of harm?
The problem that has occurred as a result of Lugo is we've gone so far afield that the question of reasonableness is only placed upon the plaintiffs. The burden should remain that all parties need to act reasonably. We all have an obligation to take measures to protect ourselves. The plaintiff has that burden clearly, but the defendant also has, and in Bertrand, the court reaffirmed consistently and even Lugo gives lip service to it, that there is a separate duty to take measures to render something reasonably safe. And Justice Kavanaugh, in his dissent, I think in Hoffner, clarified that he could have used different language and that what he was talking about was the standard of care. It wasn't that there was no duty, but rather that under those circumstances that presented themselves, the duty was not breached. The standard of care was not breached. This defendant did everything it could have done. In our case, for example, if we had evidence on the record that our defendant, not our defendant, his defendant, did something, showed some concern at least, he literally said, "I don't care," to my client. And that is the problem with where we are today with Lugo. We have granted immunity to defendants to act irresponsibly, shifted the entire burden back onto plaintiffs, and the result is that people are barred, not cases dismissed on summary disposition because they have a weak case, not a jury dismissing, but people can't even get through the front door to the court to have their case heard before a jury.
So, counsel, I understand that, but back to Justice Kavanaugh's point. So if it's a staircase, there's nothing wrong with it. It doesn't have a broken step. There's no snow or ice. It's just a staircase, and someone falls. Does that go to a jury?
No, not necessarily. There can be circumstances where the court says, under the circumstances of this case, this is as the court did in Bertrand. This is an ordinary step. There is nothing unusually. There's nothing this defendant could not have taken more reasonable. We're talking about the reasonable person standard, which we consistently use in our jurisprudence and have forever. A reasonable premises owner has to make sure that their premises are safe for invitees, that they're literally having, "Hey, come here, spend your money here." The ramp in Novotny, the courts can say, based on whatever record is before them, these are fact questions. Depending on the facts before the court, a court can say and does and do that under the facts of this case, there's no genuine issue of material fact that any reasonable
C10. They would potentially win on a C10 motion.
They could win on a C10 motion. And again, C10 also talks about reasonable. We're talking about reasonableness. What we have under Lugo and Hoffner is not reasonable. And in terms of the plaintiff here, even under livings, I suggest that that it was effectively unavoidable, because livings relied on comment F, that, I'm going to mess up the language, give me 1 second. That where the invitee will proceed to encounter the known or obvious danger because to a reasonable man in his position, the advantage of doing so would outweigh the apparent risk. So to this end, our plaintiff, who needed to fill her gas tank, went to a gas station that she had gone to before. We have no record that she could have paid at the pump. She did what she had to do. She had to prepay. She had cash. Walking in, wearing a pair of boots, and she slipped and fell because he did nothing. And when she told him, I slipped, you need to shovel that, he said, I don't care.
What if that whole set of facts had happened last week during the ice storm?
Right, and I'm glad you brought that up, because as I was salting my walkway, I thought of this case. I have a caregiver that comes to my house. I have a child with a disability. And I knew that she was coming that day, and I salted. First of all, I told her she didn't have to come Wednesday. I salted and then texted her and said, I salted the walkway, and I didn't do it because I was afraid she was going to sue me. I did it because this is common courtesy. And what Lugo has done is literally eroded the basic common courtesy that business invitors have to business invitees. We do these things because it's the reasonable thing to do. Careful, I salted it, but stay away from the half that I didn't salt, whatever. That's reasonableness.
Okay,
You're just asking for a bet.
Okay, so let's assume someone salts. They have a thing every morning in the winter, they do salt. But the ice storm hits, and it comes really fast. And another layer of ice lands on top of the salt. There's warnings telling people, please don't drive, recognizing some people have to, they do have to get gas. That person slips and falls. So is that, under your analysis, would that be a jury issue, whether the premises owner acted reasonably? I mean, I'm just... Again,
it depends on the case, and again, we go back to Quinlivan. They have to take reasonable measures within a reasonable time after an accumulation of ice and snow. No, they don't. Again, if the evidence, if there was a record showing, and by the way, in our case, the snow plows were out plowing the main road, so the government entities with governmental immunity were plowing. So obviously, there was sufficient time for our defendant to do something. So we're going back to the question of reasonableness. And I see I want to reserve my last 2 minutes.
Yeah, I still have questions, sorry. Let's take the facts of Lugo. If we had the third restatement in place when that was decided, how would that case have come out? If you were the trial court judge?
Lugo, they didn't need to do what they did in Lugo. There was a unanimous, they would have affirmed that summary disposition unanimously. The terminology that
would it be C8 or C10?
On C10 grounds, that there was no genuine issue, because there's a duty. The duty was, there was an invitee or an invitee. There's clearly a duty.
Right, so then we have to develop the facts to determine the next stage.
Did the defendant breach its standard of care with respect to that parking lot? And there was, the bench entirely unanimously agreed that they would have affirmed summary disposition. So not every single case is going to go to a jury. We have plenty of safeguards in place, more so than they did under contributory negligence. Defendants still have an open and obvious defense. They still have, under 602-959, if a plaintiff is more than 51%, more than 50% at fault, she's going to lose. So she's going to get there will be no non-economic damages. I apologize.
I know what you meant.
Counsel, can you, so let's say we were to agree with you that either Lugo was incorrectly decided, it's unworkable, it's been misapplied, we need to correct course. Why the third restatement as opposed to, say, sort of tweaking the second or adopting sort of the Levin-Kavanaugh dissent in Riddle of saying, yeah, I know that the second restatement doesn't say duty or standard of care, but the only reasonable way to understand it is that, and let's give actual effect to that phrase, unless the landowner
Right.
should anticipate that the person is going to have to confront it anyway.
Um,
Why third instead of a better second?
Think of applying the second restatement as written and in full and giving full force to all clauses and all subsections, 343C as well as 343A1, the last little bit of it, would resolve this case. I think you could resolve this case on that. My concern, frankly, is the future. Because we've seen what's happened with the muddling of the terminology liability and duty, I could see that, I can foresee that happening again in the future. I think we need to modernize the language we use to be consistent with comparative negligence. The third restatement was written in a comparative negligence framework, and to that end, it tells practitioners and courts, this is the duty that's owed, and under comment K, here's how you apply the open and obvious doctrine. And again, taking out the word entrance and using the word invitees fixes all of the concerns that the defendants might have.
And counsel, I realize we only have invitees before us today, but, I mean, obviously the next question would be licensees. Would this be like the whole, obviously, the third restatement, they're pretty blanket, it applies to everybody. Would you agree with that?
No, I don't. I don't agree with that. And I don't think we need to do that. This court does not have to adopt it in full. It can do what makes sense. Our case law is clear somewhat. We have the status-based duty. We have the standards of care set out in STIT. I don't think the sky is falling. I don't see the floodgates opening up with all the factors that are in place. And I'm out of time.
Thank you.
Thank you.
May it please the court, Don Brownell on behalf of the defendant appellee. In this case, we have jurisprudence in the state of Michigan that has been in place for over 100 years. Duty is a question of law for the court. Duty is a question that the courts decide so that we know what the standards are. Michigan law has been clear and concise for years. And the allegation that there is some need to change the long-standing law in the state of Michigan because of Lugo is simply not true. The law in Michigan has always been, dating back to the late 1800s, that the premises possessor has certain duties, and those duties involve the condition of the premises. If the condition is open and obvious, and it's a reasonable standard, not a subjective standard, a reasonable standard, then the premises possessor can expect that the invitee will recognize the danger and react accordingly. But even there's exceptions, and the restatement second tells us that those exceptions do in fact exist, and our law has adopted them. The fact of the matter is Lugo is not an aberration, but Lugo is merely the court articulating from Bertrand and Riddle that there may be exceptions. There may be situations where even if the danger is open and obvious, that the possessor will have a duty because of the unreasonable nature of the risk itself or the danger is effectively unavoidable. And in that case, Lugo actually provides invitees with greater protections, and yet counsel would like us to overturn Lugo. It actually provides greater protections than we had after simply Bertrand, Riddle, and the rest of the case law. So Lugo tells us that in a case like Livings, decided by this court recently, there is a claim that can proceed and a duty that can proceed due to the fact that the danger is effectively unavoidable.
So counsel, maybe I would agree with you in theory that Lugo should work that way, was written that way, was intended that way, and maybe even the concurrence that suggests that hopefully that's the way it's interpreted, right? What do you make of the fact that it just has not been applied that way? That the unguarded 30-foot pit or the effectively unavoidable only exit from a building haven't been examples, or clear examples, even on one, there's a big difference between falling off a regular curb and an unguarded 30-foot deep pit, right? And so that was an example of it, but I think it's fair to say, and tell me if you disagree, that the lower courts have been interpreting it as unless it's one of those two, and perhaps even it has to be both of them, but unless it's one of those two, that's the only exception to the open and obvious doctrine.
Well, I would certainly not necessarily agree with that the lower courts are interpreting in that way. What we see in the opinions is that first and foremost, the premises possessor has to conform with the duty. If it's a latent defect, a defect that cannot be known by the invitee, or there's an expectation they won't know it, there's still a duty. It's only when the danger itself is open and obvious. And let's think about that term, open and obvious. The example that was given about the ice storm last week, that's an open and obvious condition that all Michiganders recognize and see.
Oh, counsel, if I could ask you a question based on that, how does that apply to someone who's blind?
Well, in that situation,
And I know you're going to say chicken shack, but what I'm asking for is kind of just like a common sense perspective. I mean, basically, you had indicated that based on these circumstance situation, this is something that all people are able to appreciate. But I guess the question as it pertains to Lugo is, how does a blind person appreciate the risk?
well, the blind person appreciates the risk the same way a blind person functions in the ordinary world, by taking certain steps due to their unique condition to address those conditions themselves and to look out for those things. But again, we as a society, and these cases clearly indicate throughout, and I would disagree with the presentation that it's a subjective issue. It's not. It's a reasonable objective issue because the premises possessor has to understand their clear, concise duty. What duty do they have? And what expectations should they have based upon the condition of their property?
But then, counsel, going to that, and I totally hear what you're saying, but going to that, if you could address Sister Counsel's argument, which is, doesn't Lugo ultimately, in a way, and open and obvious, kind of incentivize the notion that the more dangerous the situation is, the ultimate less liability exists for the defendant? So doesn't it create kind of a perverse incentive for landowners and businesses to kind of allow for the danger to become larger or bigger, because the bigger or more noticeable it is, the less liability they're ultimately going to have, which then impacts the ability for people to transverse property, or disabled folks to be able to go in and out, or people who are blind. So doesn't it, in a way, create this perverse incentive to make something more dangerous than less?
In fact, Lugo just the opposite. Lugo tells us that in your scenario, if, in your example, the premises possessor has a danger that's increasingly dangerous, excessively dangerous, then we see the exception. We see the exception, even though it's an open and obvious condition, because it's an unreasonable risk of harm to the invitee, we will allow that case to go forward. We will say that risk.
But do those cases go forward? It doesn't seem like very many get to go forward.
Well, I would say that if a premises possessor had such a dangerous condition that it was recognized to be an unreasonable risk of harm, I seriously doubt those cases are coming here. That's going to be a claim made and a claim likely paid. Why would that case be litigated? Because to the example that was given by Justice Bernstein, if the premises possessor allows the danger to get progressively worse and worse, and then a claim is made, the premises possessor is not going to go forward with that. And so that's why you don't see them. But you do see the exceptions.
Doesn't Lugo incentivize somebody, unless it gets progressively worse to the point of a 30-foot unguarded pit, you're good, right?
But you're not good because there's multiple exceptions. One, you could have a danger, such as in livings, that cannot be avoided. So an ordinary condition that we all face, ice and snow. In livings, we see a situation, which comes from Lugo, by the way, that it's effectively unavoidable. So again, although the case, what we're looking at is public policy and the law that gives that expectation to premises possessors and invitees. Now, specific fact patterns create specific issues, and such as in livings, you've got a situation where it's unavoidable because the person needs to go to their job. So that case goes forward. It doesn't mean that that defendant is responsible, but it does mean, to answer an earlier question, that there's going to be an entire case. And any argument that, well, this can all be solved by just letting everybody have a case that goes to a jury is not a workable solution, because
Well, let me, ask me this, I guess or answer me this, I should say.
Can I?
Yeah, ask me. I'm trying to figure out, I mean, and maybe there is an answer to this, of, like, what is this sort of unique fragility of premises law in Michigan? Since we've adopted comparative fault, parties, including their insurers, have been evaluating the reasonableness of the defendant's conduct, the reasonableness of the plaintiff's conduct, the causal connection, the extent or existence of that, and the nature and extent of a plaintiff's injury in evaluating a claim. And so it's not just that Michigan and its application of Lugo is sort of this anomaly across the United States. It's also an anomaly to our negligence and comparative fault within the state. It's like this unique animal. Is there something special or unique or like that needs a duty? It needs to have a duty defined in terms of what the plaintiff's conduct is. Like, what is special about premises liability that requires this departure?
Well, one, I would disagree that it's a departure. What we have in the premises liability space is clear, concise expectations of obligation. Expectation of obligation on the premises possessor and on the invitee or licensee, if you have a different standard. And we do adopt this in other areas. We adopt it in simple tools. We don't have to warn people that the knife is sharp. They know it. And even if they cut themselves, and they make a claim against the owner of that knife, there's no duty there, because there's no duty to warn. And the same is true here. And also, Michigan is not an outlier.
But there's nothing wrong with the knife.
There's nothing wrong with the knife.
Right.
There's nothing wrong with the steps either.
Yeah.
They're a condition that
Right.
you're going to face.
I
There's
agree with
nothing
that.
wrong with
Yeah.
snow on a parking lot or ice on a parking lot in Michigan during an active snow event. It is not the premise possessor's duty to ensure the safety of every invitee. That's
But
not
yeah,
their duty.
I mean, I will say, most businesses I walk into, I notice the front door is salted. So but you're saying they don't have to?
Well, when you say you notice them salted, if you were out in the active ice storm last week, if you had left your home in the active ice storm when they said don't leave your home, you likely would have found a business, if open, where they hadn't gotten salted yet. Maybe the contractor hadn't come yet. So you
But
would have
let's focus
chosen to
on
do that.
But let's focus, if we could, on your kind of your traditional person, right? You're going into a parking lot. There's the challenge with Lugo is, again, is that you're creating an objective standard. Shouldn't it be more subjective as it pertains to the fact that you're coming at it from the perspective, and correct me if I'm wrong, that all people can appreciate the risk? And the question here is, can all people appreciate the risk? And at the end of the day, the real issue here is, it's not during an ice event or a snow event or what have you, but it's just your kind of standard situation where ultimately, under Lugo, the larger the ice, the more, the bigger the ice, the better it is in terms of, the defendant's liability. That's what creates a lot of challenges for ordinary people, people with disabilities, and I say blind people, right?
And in response, again, what the court is being asked to do here is to change the law of the state of Michigan that's been in place for 100 years. And to not just change it slightly, but if the court were to even consider adopting restatement third, it would change it completely. We would get rid of status, we would get rid of all the issues, and there would be no ability for premises possessors to understand their potential duty and their potential liability. We need to have laws that businesses can rely upon, that insurance companies can rate risk for, and we need to do so generally.
Why can't an insurance company rate a risk that says a premises possessor has to exercise reasonable care to prevent a risk of harm?
Because now every claim ultimately ends up in front of a jury.
Why? No. I mean, I don't think that that's necessarily helpful, because not every claim ends up in front of a jury, right? I mean, I think we've established that. The first stairwell in Bertrand wouldn't end up in front of a jury. I don't think the pothole in Lugo probably would have ended up in front of a jury. So where, like saying it's either everybody, you know, no plaintiff can succeed or every plaintiff gets to a jury is really probably not accurate and also sort of not helpful in deciding what the standard would be. So why can't an insurer evaluate, and the premises possessor, right? Because every business owner also tends to be somebody who goes on somebody else's property, right? This isn't just a pro-premises owner or your pro-occupant. Everybody, you know, maybe not everybody owns property, but just about everybody goes on somebody else's property. You're on somebody else's property here today. Like, so why can't an insurer evaluate the risk of saying, look at they have a regular stairwell. It complies with code. There's nothing special about it. It doesn't have razor blades sticking out of it. It doesn't have, you know, like clowns in front of it making you like, not, I mean, it's a regular stairwell. That risk is pretty minimal because I'm not going to have to pay out on a claim if somebody falls on that stairwell.
Well, if we were to follow the adoption of what's been asked for, and if this court were to change the jurisprudence in the state of Michigan, at a minimum, you're going to face a litigated claim. You're going to face a claim that gets to the end, and then you're going to rely upon a balancing under C-10
But
of
are
whether
they
that claim
claims
goes
that
forward.
should get to the end?
Well, should a claim of an ordinary step, to your example, should someone who doesn't look out for their own safety, and doesn't see the curb, doesn't see the step,
So let's say
and
the
trips and
ordinary
falls.
step doesn't get to the end of a claim.
But
But if
if it
somebody
doesn't get there-
falls because there's no handrail or because the stair is broken, maybe they ultimately don't win, but should they at least get to the end of a claim and have a jury decide whether they should win?
Well, just like in Bertrand, they may get there because of the particular condition as alleged, but if it's an ordinary step and they merely just fail to look out for their own safety, the question is, what is the duty of the premises possessor? And the answer there is, there isn't one.
Would the second staircase, whatever it was, in Bertrand, would that have survived summary under Lugo?
Yes, because Lugo didn't change Bertrand.
Well, no, how would it have done that? Was
Because-
it unreasonably dangerous or effectively unavoidable?
I think the court would have said that in that case, it was unreasonably dangerous because of the distraction factor, and in that situation, they would have let it go forward. All Lugo does is provide us with additional guidance for additional exceptions under the open and obvious doctrine. And I think...
But it moves it to duty. So like you opened with, for 100 years, the jurisprudence has been the same. I'll be honest, we've got a bunch of students here. When I went to law school, torts 101, duty, breach, causation, damages. Duty was just a question of, do you have a duty to the person coming on the premises? Then you move to the next step. I mean, didn't Lugo actually pretty significantly detour the case law, at least how it's been applied?
Well, certainly Lugo, when you read the decision, it did not. Lugo merely takes us forward from what we had in Riddle and Bertrand and brings it forward and tries to articulate the actual exceptions that are even seen in the restatement second. And it tries to give us words that we can rely upon to use those exceptions. That's all Lugo does. It doesn't change anything. And in fact, when you look at Lugo and Hoffner, Michigan has come up with essentially an answer that works for Michigan. And, you know, quoting Justice Clement in the decision that was recently issued by this court in Livings, that this balance has worked for us. And that's the important thing. The balance has worked in the state of Michigan, and in other states, they have not gone forth and adopted the restatement third. They have not gotten rid of this kind of open and obvious as part of duty. And
But they
that's where it
also don't
lands.
have special aspects either, do they?
They haven't used the words, but it's still there. Special aspects was even there before. Lugo again tried to give us additional exceptions and tell us what they were. I see my time's up. Thank you.
Thank you.
Counsel, before you go, I just want to make sure I understand that what you're saying here today is the special aspects are just illustrations of the restatement second approach. In other words, examples of when a premises possessor should anticipate harm.
Correct.
And so it seems to me you're agreeing to some extent that the special aspects doctrine may have caused confusion or changed sort of the focus or become too much the focus of our law. I don't want to put words in your mouth. Are you agreeing to that, or are you acknowledging that?
I'm not agreeing that it's created an issue. I'm saying that the Lugo court, in doing what it did, essentially was attempting to give additional guidance to certain situations that may be specific exceptions to the open and obvious doctrine, unreasonable risk of harm.
But those don't need to be the focus in every case. I mean, that's become the focus of our case law. We've had lots and lots of arguments, and I just want to, so maybe you don't agree or aren't willing to concede how much of a problem there is, but it sounds like you're not opposing this, a partial solution, which would be just to clarify that special aspects are simply an illustration or illustrations of the restatement approach that we have followed more or less for the last 100 years.
Well, I would say that Lugo does that already, so there's no need for this court to clarify anything. There's no need for this court to clarify because we already know what the law is and we've seen it work.
But what have we done over the past few years with special aspects? Hasn't it been winnowed away to almost nothing?
When you say whittle away to almost nothing, there are certainly cases coming down from this court and others that say, well, it's effectively unavoidable. In that scenario, we're going to let it go forward, and we've increased what effectively unavoidable means. It was, I can't get out of the building. Now it's, I can't get to my job.
Don't we have to take all of this and provide some clarity there?
I don't believe so, because in this scenario, what we have is, the case before us here is a simple fall on a recognized open and obvious condition. There's nothing special about it. There's nothing to be done in this case. This is an everyday, ordinary Michigan case. The question becomes, in a case like Living's, was there a need to clarify that someone getting to their job was facing an effectively unavoidable situation? Possibly. But there's no need to change our long-term jurisprudence, and certainly no reason to accept this case.
But doesn't the avoidability go to being able to, I mean, doesn't it all go back to that same question, which is the avoidability has to go to appreciating the risk? I mean, you can't avoid something unless you can appreciate the risk, and not, it just goes back in a circle, right? Not everyone can appreciate the risk because not everyone's able to understand what the risk is.
Well, again, your question presumes that we're looking at a subjective standard from the focus of the invitee, as opposed to the duty which we're going to place upon the premises possessor. And that's really the issue here, is we're looking at the duty on the premises possessor first and foremost before we get to other factors.
But isn't that really what the problem is, though? Is that it creates an objective situation, not a subjective one. And not everybody can adhere to that objective standard, even though you're talking about it from that perspective.
But we're talking about it as a reasonable objective, just like the restatement talks about. It's a reasonable standard based upon the premises possessor and their obligation to generally determine, are there any defects on my premise, and what should I do about them? Do I know about them? Do I need to warn about them? That's what we're doing. We're not giving them hypotheticals of other situations, because at that point, essentially the duty is assumed by the exception itself.
Thank you.
Thank you.
Thank you. The case will be submitted.